So the second speaker would be coming up now, and she would be taking us on governance and AI standards, models for court rules. She would examine the legal framework, policies, comparative court rules, best practices, jurisprudential challenges, and recommend some reforms. So actually, she's from Kenya, so she's going to give us the Kenyan perspective of application of AI in legal proceedings. So before us, we have Miss Naomi Gichuki. She's an advocate of the High Court of Kenya and a legal consultant with over 15 years of extensive experience in legal research and training. Her expertise spans providing legal support, curriculum development, policy analysis, and capacity building, particularly within the criminal justice system. She's a passionate advocate for the rule of law and safe societies. She has worked on numerous projects enhancing the capacity of law enforcement, prosecutors, and judicial officers. She is also published author, a doctoral candidate, and holds an LLM specializing in advanced constitutional law, human rights, and regional integration. So please join me to make a very warm welcome to Miss Naomi Gichuki.
Thank you, Lillian. Thank you, Lillian. Good afternoon to each and every one of us. It's a pleasure to be part of this very interesting and very exciting forum this afternoon. As Lillian said, my name is Naomi Gichuki. I'm an advocate of the High Court of Kenya and a legal consultant. And I was invited to talk about governance and AI standards, models for court rules. And like the previous, or rather the facilitator said, I will be looking at comparative court rules, I'll look at the legal and policy frameworks, digitalization in the administration of justice, which you will notice is primarily the focus of my paper this afternoon. Then I will share the challenges and success stories that we have had from the Kenyan perspective. Now, by way of introduction, one thing that has become very evident, especially over the last decade, is the aspect of digital technology and how it is being deployed at various levels. And this was especially fast-tracked or accelerated post-COVID, where we saw everything suddenly, adopt a digital approach. And government services have not been left behind. Judicial services have not been left behind. Administration of justice, and like the previous speaker so well elaborated, the use of technology also in delivery of legal services from the perspective of legal professionals actually deploying AI and other forms of technology to ease their work or to enhance efficiency. And there are two key aspects that are very pertinent in any discussion on digitization of services, digitization of administration of justice. And one of them is digital public infrastructure, but the other is the place of artificial intelligence and the role that it has to play in transforming or enhancing the different systems that we already have in place. Now, the digital sector definitely remains a big driver, not just of innovation, but also in changing the landscape of work. And those were good questions that were asked about the role of legal professionals. And towards the end, I'll also share some insights on what has been happening on the Kenyan side. Now, Kenya was rated among the top 15 countries during a recent UN survey on e-government services, and specifically with regard to provision of online services. Kenya has actually managed to digitize quite a number of government services, whether it's licensing, registration, even lands, issues to do with land transaction, court processes. There's a lot that we actually currently do online within the Kenyan context. And this is in line with what we commonly call the bottom-up approach, which was the government's blueprint for bottom-up economic transformation agenda. And one of the pillars of this agenda is the digital superhighway, which in itself has 5 pillars, including digital infrastructure. But I'm going to focus in this particular presentation on the use of digital technology to enhance government service delivery, and more specifically, the administration of justice. Okay, so the legal and policy framework, I'm glad the previous speaker spoke about the legal framework in Nigeria. One thing that I would say we also have in Kenya is the absence of a robust legal framework that specifically addresses artificial intelligence. So in the context of administration of justice, we'll start with the primary law, which is the Constitution of Kenya, that sets the stage for establishing judicial authority and the legal system. And it also sets out the principles that bind courts and tribunals in the administration of justice and in exercising judicial authority. One of the key and especially key principles that have been, a hallmark of exercise of judicial authority in Kenya, especially after the promulgation of our current constitution, which is fairly recent. Our constitution is from 2010, is the aspect of justice not being delayed, so timely justice, as well as not having undue regard to technicalities. So we've seen a shift in exercise of judicial authority with really embracing these 2 principles to ensure that justice is delivered in a timely manner. Then another key pillar that would be important to note in the discussion on administration of justice is the judiciary transformation framework. And it had about 5 pillars, but one of the key pillars of this framework was harnessing technology as an enabler of justice. So the framework, which was developed in 2012 or thereabouts, envisaged a judiciary that will adopt and utilize technology, not just for digitizing records, but also adopting the use of teleconferencing facilities, digital recording of proceedings, and establishing electronic case management systems. Now, Kenya at the moment does not have a comprehensive legal framework that covers artificial intelligence. In fact, what is currently in place is a draft strategy on artificial intelligence. So I would say we still have quite some distance to cover in terms of having a robust policy and legal framework. We have the Kenya National ICT Policy, which envisages all government services being available online. Currently, we have about 2,800 government services that are being offered online. So it's very possible right now to have a lot of issues resolved online without having to go to a physical office. And this policy envisages all government services being delivered quickly and fully, and at the time and place where they are needed. Are we there yet? Not quite, but significant strides have been made in this regard. Back to the judiciary, we have the social transformation through access to justice, which envisages adopting people-centered justice technology. Now, the idea is not just to make legal and judicial processes accessible, but to also promote efficiency and make sure that the processes are user-friendly so that the ordinary consumer of justice services is actually able to access justice, able to understand the processes, to have access to the processes, and it has served to a large extent to make the judiciary, feel more reachable to the ordinary man. Now, this aspect of judicial or people-centered justice technology isn't just with regard to, the consumers of justice, but also legal professionals. And we'll look at that a bit later in the presentation, as well as other stakeholders within the legal system. Then we have the 2020 Electronic Case Management Practice Directions, which basically apply to all the courts and are meant to guide the court users with regard to integration of information communication technology in judicial proceedings. So I'll now proceed to discuss digitalization in the administration of justice in Kenya. And as a background, I talked about the Judicial Transformation Framework, which is the primary document that really has or sets out the blueprint that the judiciary was using in adopting technology in the delivery of justice and administration of justice. So the COVID-19 pandemic definitely fast-tracked the adoption of digitized court services. And in 2020, a lot of our courts actually went virtual. It was a bit abrupt, but it took place. And with that came up the development of guidelines in form of the electronic case management practice directions. So these practice directions actually give a breakdown of what to expect in the process, what the process looks like in terms of e-filing. And this e-filing, like I said, initially started in the capital in Nairobi. So we didn't have it in all the courts. Not all the courts were able to go virtual. But from 2024, the e-filing system has been in use for all courts across the country. There's also been an investment of about maybe 2 million USD, which is about 250 million Kenya shillings, that was invested by the government to connect different court stations across the country with high-speed internet to ensure that the e-filing system is working, but to also ensure that delivery of court services to virtual courts is able to take place across the country. Then we have the e-filing and case management, which I said was introduced around 2020 during the COVID pandemic. And the e-filing system basically includes case registration. It allows for assessment of cases. And it also provides for an electronic diary, methods of payments of fines through the same system, signatures, exchange of documents, and it also gives access to the daily cause list. So anyone that would want to know what matter is being heard in whichever court across the country is actually able to access this information. And in recognition of the fact that not everything would be, able to be transferred into a digital format, there's also the option in these rules that permits alternative technology or manual filing. But again, this is subject to the discretion of the court. So in as much as we've shifted to e-filing, there are still aspects where certain components may be filed manually as and when the need arises. Okay, so we also have the uadilifu system. Uadilifu is a Swahili word. Kiswahili is one of our national languages. So uadilifu means integrity. So this system is used exclusively by the ODPP, that's the Office of the Director of Public Prosecution, and has been in use maybe for the last about 2 years. And it's a comprehensive system that sets out different aspects of file management and case management for the public prosecutions. It's also linked to the judiciary, meaning that there are certain documents, for example, charge sheets, where we're no longer using, physical or hard copy charge sheets, but the charge sheet is generated through the system, and then it is transmitted to the judiciary, who are then able to, assign a case number. And this has been a significant stride because it has enhanced transparency in the entire process. I'll be looking at the gains that we've made from the use of technology in the administration of justice a bit later in this presentation. For the Uadilifu, there's also a mobile app that is specifically on the decision to charge guidelines. Now, the decision to charge guidelines are guidelines that were established for the Office of the Director of Public Prosecutions to inform law enforcement agencies on the parameters to consider and the nature of charges that, that should be profiled against accused individuals. And what this has done is, because there are multiple law enforcement agencies that have a mandate to investigate different issues depending on the nature of the matter, the mobile app is a useful tool that puts all these guidelines that would inform their processes in one convenient place. The ODPP has also adopted learning management systems to streamline learning, and there's been enhanced service and interlinkages with this Uadilifu system and other actors within the criminal justice sector. Then about 2 months ago, the judiciary also launched the e-judiciary app. This is actually available on Play Store for download. And what it has done is to consolidate and make available judicial services in one app. So you can verify court orders on this app. You can get information on different matters, including probate and administration matters. You can track the progress of a case. So with tracking the progress of cases, we also have what is called the judiciary kiosk. And if you go online and Google Kenya Judiciary Kiosk, it will take you to a public information portal where you key in different details of a case and you're able to track the progress of cases. You are able to tell how far the case has gone from the time it was filed in court. You're able to tell what happened during the last proceedings. For instance, if it was a mention, if it was a hearing, you're able to tell when the matter will next be heard. And so it has helped to reduce the complex nature of getting information from court systems. If a layman, for example, was to just walk into the court's registry and ask for this information, it is much easier to actually access this information online. Then this app also provides for, it gives access to the cause list portal, which I had talked about, that states all the matters that are being heard before any court within the country. And it also gives users access to the judiciary's e-filing portal, in addition to the judiciary advocate management system. Then another stride that we've made in terms of automating judicial administration is going paperless. However, this is only at the Supreme Court level and at the Court of Appeal. Of course, it has significantly improved service delivery because judges are no longer taking proceedings in longhand. And thus, this naturally cuts short the amount of time that is taken to hear and determine matters. On the same note, the Office of the Attorney General has an ICT help desk. And again, they've also adopted the use of this system when capturing data, in addition to developing in-house case management systems to keep track of the different cases and parties. Now, another actor that is very crucial to the justice sector is the National Police Service, and the National Police Service has also adopted the use of a digital occurrence book. So the occurrence book, as the name suggests, is where all reports filed to the police are made. So every police station has the occurrence book. Unfortunately, the digital occurrence book is not in use at all police stations. And this is part of a larger reform process to ensure that police services are streamlined and there's transparency and efficiency in service delivery. So this occurrence book is the digital occurrence book is one of the major strides that have been made in that regard. We have what I had mentioned earlier, the Judiciary Advocates Management System, or JAM, which basically has streamlined services for legal professionals that are in one way or the other connected to the judiciary. For example, admission of advocates, that's a process that is naturally done or channeled through the judiciary. And this system, this virtual digital system, has made the process easier. When I was called to the bar about maybe 13 years ago, everything was manual. You have a bunch of documents, you need to present them to different offices to get stamped. You move from one office to the other, and it was quite a lengthy process. But now everything is online, so you just need to have your paperwork in order and you upload these documents. And this system is being used to enhance efficiency, not just in admission of advocates, but also with regard to the issuance and the application, the processing, and the issuance of practicing certificates, notary public certificates, commissioners for oaths. So anybody or any advocate that requires to, petition to be granted the right to be a commissioner for oaths or a notary public would also go through this system, and it's fully virtual. In the pipelines is the evidence management system. This has not yet been implemented. I'm not aware of how the system is in Nigeria, but one of the biggest headaches in the criminal justice system in Kenya is chain of custody of evidence. Cases have really, been aborted because chain of custody was broken. We don't really have sound systems to record and manage evidence. So this is something that's still in the pipeline, but the whole idea is to ensure that the storage and transmission of evidence is done in a more secure manner. Then we also have the National Council for Law Reporting, which if you go online is what is kenyalaw.org. Now, kenyalaw.org is a fantastic platform that puts together multiple resources for legal practitioners or law students. So the laws of Kenya are captured on kenyalaw.org. Reported cases from way back, literally from the colonial era in Kenya. We have all those cases available online, and they come with summaries of what the case entails. So if you wanted to do a quick search, it's actually a very interactive platform, and it's been around for several years. So over the years, they've been improving. Of course, there's still more that can be done because there's no, for example, it doesn't have a chatbot that you can chat with or an AI tool that you can interact with on the website itself, but it does present a lot of legal resources in a very comprehensive manner. Kenya Law also has a daily course list. So it's another platform that is available to court users to download the course list. It has bench bulletins, updates on recent cases that are coming from the court, as well as the Kenya Gazette, which is released every Friday. Now, having outlined the different ways that technology has been deployed in the administration of justice, I would like to talk about the gains and the challenges. Now, one of the most phenomenal, I would say, gains that we've had is access to justice. There's been improved and expanded access to justice. It is cheaper to file matters. People no longer have to travel long distances to come to court physically to attend physical court. And there's also been reduced reliance on physical courts. And this has cut costs not just for court users, but even for other actors within the criminal justice sector. Because like during the COVID, I remember during the COVID pandemic, we actually used to have virtual courts sitting in prisons. So that also helped to reduce the backlog because there was no reason for them to come to court or to have unnecessary adjournments for any reason. So this has actually helped to fast track processes. Then there's efficiency in service delivery. Digitization has significantly reduced the amount of time and effort that is required to file matters. Some of our registries were extremely busy. So you'd find that if you go to file a matter, it could take you 2 or 3 hours just to, put your papers and have them at the registry. So the fact that this can be done from the comfort of your home or office has really helped to enhance service delivery. And then another aspect that we cannot underscore enough is the transparency and accountability in service delivery. The fact that we are now able to trace the movement of a case from the time a matter is filed, how long it has taken in court, what has been going on, has really created a sense of transparency and has instilled more confidence in the judicial sector, because previously this was not information that you could get at your fingertips. You couldn't easily access files, for example, to just trace the movement of a file from the time a matter is lodged to the time the case is heard. So this has really helped. And then with the Uadilifu system, again, it has also cut down the opportunities for human interaction and avenues for corruption. Once a charge sheet, for example, has been inputted in the system, it cannot be deleted. It can't be taken down. So we don't have instances where court charge sheets are disappearing between the Office of the Director of Public Prosecutions and the courts, because the two systems are now integrated. So once a charge sheet is generated by the public prosecutor, it's automatically transmitted to the courts without need for any intermediary. And of course, a reduced human interaction also reduces the avenues for corruption, which is a significant gain. I'll proceed to address the challenges. Kenya has high internet connectivity, but we still have last mile connectivity challenges in certain parts of the country. So they don't have sufficient infrastructure to enable them to be fully virtual. And this is a challenge. Then costly internet services. We have amazingly fast internet in Kenya, but it's very expensive. So the internet costs can be prohibitive in terms of being a barrier to accessing justice. And connected to the poor connectivity is also low digital literacy. If we're going to deploy AI tools, deploy virtual platforms, digital platforms to carry out activities, it means then that the population also has to be educated. So the judiciary has done well to provide guidelines on how to use the e-filing system. So if you logged onto the Kenyan e-filing system, you'll actually find step-by-step explanations, but be that as it may, it's still low digital literacy still remains a problem. Then there are risks associated with data privacy, and the previous speaker also alluded to that when he said, the government is a large consumer or a primary stakeholder in terms of having vast amounts of data, but a lot of it is not processed internally, or we've had external consultants building this framework. So there are thin lines in terms of the back end of these programs. Who stores the data? What do they use the data for? What happens when there's a breach, and other forms of cybercrime? And if you've been following the Kenyan environment recently, you'll know that a lot of things are going on digitally, including organizing protests. So cybercrime in this country is definitely a major challenge with regard to data privacy. I'll give an example. The judiciary systems, there was a time the judiciary systems were down, and because of the timing, it was actually suspected that it was a cyber attack and not just, a regular technical hitch. The other major challenge is bias, and this again with automated systems, depending on the kind of information that these systems have been fed with, there's a very strong likelihood that if not monitored, they can actually perpetuate certain biases or give flawed outcomes. And then there's what I call unsynchronized reforms, and this has a lot to do with the poor coordination between actors in the justice sector. So they're not really moving at the same speed when it comes to digitization or even the adoption of artificial intelligence. In fact, recently we had a stern warning to legal practitioners from the Supreme Court about use of AI tools when drafting legal briefs, because it was discovered that there was a brief that was filed and it did not have correct citations. Those cases were actually non-existent. So the position in Kenya has actually been to discourage legal professionals from using AI tools until AI, rules on the use of AI have been developed. And as it is so far, we don't have any such rules, not from the court, not from the Law Society, and not from Parliament. Still on challenges, inadequate resources. Digitization requires adequate technical infrastructure, and this is a need that still is a challenge in Kenya. Not all the agencies, like I said, are moving at the same pace, so not all of them really have the technical infrastructure to fully accommodate the capacity to offer digital services. There's aspects of language diversity. Services currently on the judicial platforms are primarily in English and Kiswahili, which leaves out a large number of Kenyans, especially those that are not in the urban areas. I talked about technical glitches. When the judicial e-filing system especially has been flagged for having extended periods of downtime. So this is something that would need to be addressed, in line with also the need to integrate the agencies within the justice sector to ensure that the process is seamless. So you don't have one agency having a very functional, very robust service delivery, and then you have another that is lagging behind. And then, of course, we cannot overemphasize the need for human oversight. The absence of human oversight exposes people to bias from AI or even errors that could easily have been spotted had there been human oversight. So what are the recommendations going forward? One is to have a structured approach in the adoption of digital technology among actors in the justice system. The justice system has different stakeholders, and it becomes a disservice when one actor within that system has really developed and adopted technology and the others are lagging behind. So it slows down the entire process. So in line with that is the need to integrate digital services, where services should be interlinked to ensure that there are no loopholes, and also to ensure that the data gathered is synchronized, is harmonized across the different agencies. There's a need in Kenya especially to deploy technology in court processes. Court proceedings in the high court and in lower courts are still being recorded in longhand. This really wastes a lot of time. We have not really fully automated our court processes. So that would be one of the recommendations that I would advocate for. I know it's currently in use at the Supreme Court level and Court of Appeal, but the traffic in the larger, in the bigger picture, there's more traffic in the lower courts, in the high courts, so there's need to deploy technology in these courts as well. Promotion of digital literacy. There is need for concerted efforts to enhance digital literacy among citizens, but even among the officers who are responsible for manning this system, so that they're able to offer robust services, and for the consumers, so that they're able to enjoy the full capacity of these resources that they have at their disposal. There is need also for increased funding to make sure that issues of infrastructure are sufficiently dealt with. As courts are going digital, they need to ensure that all supporting infrastructure is there, and not just for the courts, but also for other agencies within the justice system that play a critical role. Internet affordability is another that would need to be looked into. Just the need to regulate service providers to ensure that internet costs are affordable to the average Kenyan. Legislative and policy frameworks. I mentioned at the onset that we don't have a robust framework that sets out, the rules or even laws on the use of AI, not just in the legal, in the confines of the legal services, but generally. So that is something that would need to be prioritized to ensure that there is a sufficient governance framework to address issues of privacy, cybersecurity, how data is handled, and related aspects. And then, of course, they need also to ensure that the present services are also being monitored and upgrades are, installed as and when the need arises. So thank you very much for your attention and your time, and I look forward to interacting with you in the Q&A. Thank you very much. Over to the moderator.
So thank you very much for the cooperative perspective which you have provided, and for some of our participants who perhaps just joined us. Ms. Naomi, an advocate of the High Court of Kenya and a legal consultant, just finished speaking to us. So, Ms. Naomi, just a few questions for you before we proceed. So, from a practical governance standpoint, what are the most significant hurdles Kenya faces in translating its ambitious AI strategies and draft policies into enforceable court rules and judicial directives that genuinely ensure ethical AI deployment and accountability within its legal system. That's one. I don't know if you want me to take that again. The
Yes,
second
please
question
take
is
that again.
given, okay, the question goes from a practical governance standpoint, what are the most significant hurdles Kenya faces in translating its ambitious AI strategies and draft policies into enforceable court rules or judicial directives that genuinely ensure ethical AI deployment and accountability within its legal system?
Okay. Would you like us to go
Okay.
one question at a time, or would you put all the questions and I can answer them in one installment?
Okay, there are just two questions. Perhaps you could
Okay.
just quickly respond to the first one, and afterwards I present the second.
Okay. I think one of the major challenges that I have observed has been the slow adoption of AI. The first presenter gave a very good illustration of skepticism towards using AI, and it's something that I would say has been a problem in Kenya. So the absence also of goodwill to adopt digitization and AI. When we had the new constitution in 2010 and the judicial transformation framework was developed in 2012, there were proposals as far back as then to deploy technology to ease court processes, and especially with transcription and recording of court proceedings. And there was a lot of resistance from within, from the bench. So that has had a significant impact on the adoption of technology and deployment of AI generally. I also mentioned the stern warning that came from the Supreme Court to advocates about using AI. So that in itself is a problem. But secondly, we also don't really have a legal framework in place. And part of this can be attributed to poor collaboration and poor cooperation between the different government agencies. So you find different agencies are moving at their own pace, moving at their own speed, trying to create, frameworks within their specific industry, but we don't have anything per se that is binding on everybody in terms of having a legal framework. So that is a problem. However, there's steps that have been made to rectify that. A few months ago, there was a launch of the artificial intelligence strategy, and I believe that is going to spearhead action from government's end to put in place frameworks that would be useful in administration of justice as well as law enforcement. Thank you.
Oh, okay. That's quite insightful. Quite insightful. So the second question, which is the last one, says, given Kenya's push for AI ethics and the broader digital transformation, how is Kenya ensuring its legal practitioners receive adequate and continuous training and capacity building to effectively oversee and apply these AI governance frameworks in their daily roles?
Okay, that's a very good question. So the Law Society of Kenya has CPD programs. So CPD, I believe the Nigerian Bar also has the same continuing professional development programs. And one of the strategies that the Law Society has deployed is to continually offer free trainings on certain emerging issues. So, for example, aspects of data protection, deployment of AI, that has been a recurring theme where the Law Society has been carrying out continuing professional development training. And then even within the judicial sector, the Kenya Judiciary Academy also has annual colloquiums for judges and magistrates. And I know this year the theme was on technology, and that also covered aspects of artificial intelligence. Of course, it's not enough to expose people to such training maybe within a day or two. We would need to have more concise strategies and to even look at how to integrate this kind of training within the legal profession rather, but also with our judicial officers and law students that are getting into the profession. So there's still a lot that needs to be done, but I would say that significant strides have been made, at least by the Law Society, in terms of availing this training to practitioners.
Okay. Thank you. Thank you very much, Ms. Naomi. That was quite an insightful presentation. So, to
Thank
our
you.
dear participant, we have been speaking with Ms. Naomi, an advocate of the High Court of Kenya and a legal consultant with over 15 years of extensive experience in legal research and training. Ms. Naomi is a published author and doctoral candidate and holds an LLM specializing in advanced constitutional law, human rights, and regional integration. So, Ms. Naomi, thank you so much for having us and sharing your perspectives on this issue. Thank you very much.
Thank you very much
So,
to all the
yeah,
participants for your questions and attention. Thank you.
yeah.